I've always felt that lawyers are problem solvers. They find solutions to problems of those in their communities. How then can we, here in Wayne County, take the problems of our most basic institution, that being the family, and solve or at least assist them with those problems? And certainly it's not by further tearing apart that institution by legalese and court orders which spell out in technical legal terms that petitioner gets custody, respondent gets visitation, and those sorts of things.
Right, and to put people through the process of suing each other to get to that.
Absolutely. Now, long after the ink is dry on that decree that I sign, it's up to these two parents to provide for their children's well-being. So at least here in Wayne County, with the wonderful help of you and through the use of your terrific website, uptoparents.org, we decided to change the way we do business in the family law arena here in Wayne County. And we decided that we, as family law practitioners and judges, needed to show a commitment not only to good legal outcomes, but rather to good relationship outcomes. Now, family law pleadings in Wayne County now are not to be stylized as the cold, impersonal legal use of terms such as petitioner and respondent. We require that the pleadings be styled in terms of mother and father. Now, Charlie, I got to be honest here. I'm a lawyer by trade. I'm not a psychologist. I'm not a sociologist. So I saw this change at first, quite honestly, as stylistic. But what I've personally observed is that with this change comes a certain respect. It's much easier to be cold-hearted and nasty with a respondent than it is with a mother or a father.
Sure, right.
And that change has been just that slight change has been a wonderful change. Now, the Wayne County local rule provides that counsel and the parties are to use good faith personal or telephonic consultation to resolve any issue before they seek court relief.
And I really want to focus in on that because it's a wonderful preamble that you have. Yet I think maybe the crown jewel of what you accomplished and put into effect 11 months ago is perhaps this core thing. And I hope someday, personally, I hope someday all of us attorneys and judges will be able to look back and say, why were we ever doing it any other way? Why were we allowing people to file motions and make that appearance in court the first time they talked about solving a problem? So maybe you can describe what this rule exactly requires in terms of the attorneys, and if the parents are not represented, then I understand they're supposed to do it themselves, what they're supposed to do before or perhaps even instead of just filing a motion and bringing something to court to resolve.
Sure. In any motion filed with the court, the motion has to include a paragraph as to what attempts have been made by the parties and the attorneys to resolve the matter before they can request any relief with the court. If such a paragraph is not included in the motion, I don't set it for hearing. It will not get heard. There has to be a paragraph specifically stating what they've done to try to resolve the matter. The Wayne County rule requires that any matter, any issue, be discussed and resolution attempted before any court time will be allowed. Now, the rule doesn't simply provide that the parties and the attorneys have consulted and that they simply were unable to resolve their disputes. In fact, it goes further. It provides that if the matter is not resolved in their conference and discussion, then the attorneys are to exchange their ideas about where the family could be sent for help, confirm that they have attended or at least are scheduled to attend the mandatory class which we have titled Helping Children Cope with Divorce, and where it's been ordered, if the parties have completed or are in the process of completing the website on uptoparents.org. So it's not enough that they, in this paragraph, tell the court, Judge, we've talked, but we haven't been able to resolve anything. They have to go further and tell us what they've done to try to resolve it and where they believe would be a good place to send these people short of the courtroom.
Well, I think that's such a fantastic thing. So give us a verdict. This has been in effect for 11 months?
I'd have to tell you that our rule has been an overwhelming success. The Wayne County Family Law Bar meets regularly, and those meetings routinely end with an ode that passing our cooperative law rule was probably the greatest rule change that we've ever made. And in fact, we redid every one of our local rules, family law, civil law, criminal rules, probate rules. We redid all of ours at the same time. And routinely, the attorneys tell us that it is this rule that's the best change that we've ever